Good afternoon. I'm Paul Truster, Program Planning Lawyer for the Department of Continuing Legal Education. And on behalf of the department, I'd like to welcome you to this afternoon's program, Taxation of Private Corporations, which is intended to be the first of a projected series under the general rubric Tax Without Terror. And none of you look especially scared, so that's a promising sign. I'll begin by welcoming today's faculty, Professor Vern Krishna and Michael Morgan, both of whom have given very generously of their time and talents in preparing the papers for this program and in presenting them today, and we're certainly very grateful to them. With no further ado, I will introduce the chairs. Professor Krishna, as the biography inside the binder indicates, Professor of Tax Law at the University of Ottawa, practices as tax counsel with Koski and Minsky, and is doubtless already known to many of you as the author of Fundamentals of Canadian Income Tax and managing editor of Canadian Current Tax. Michael Morgan, already also known to many of you, obviously, has a practice emphasizing tax planning, corporate reorganizations, estate planning, and tax litigation, and is on the executive of the taxation section of the Canadian Bar Association, Ontario, with responsibility for its continuing legal education function. Please join me in welcoming our faculty.
Thank you. I was amused when I first saw the title for this program, Tax Without Terror. Amused because I can hardly imagine anybody less terrifying than myself. I need this added height of this podium to assume any stature. Now, the subject is intimidating to some. It should not be, but it is. And it's intimidating largely because of two or three factors that are unique to this particular branch of law. And I emphasize law as opposed to accounting, because it is a branch of law. One, of course, what makes this subject more intimidating than some others is the fact that the statute is drafted in a particularly complex and convoluted manner, and therefore makes it that much more difficult to read. And yet, it is ultimately, notwithstanding the materials that you have in front of you, the final source and the sole source of authority. That is the statute, the Income Tax Act. Secondly, of course, what makes the subject somewhat more formidable is the fact that the statute changes very rapidly. It is amended at least once a year, more usually 2 or 3 times, and there is an environment of uncertainty therefore created through those changes. Notwithstanding that, however, at its basic levels, there are fundamental principles and methodology that can be digested and understood and applied on a continuous basis in a changing environment. And I hope to go through some of that with you in the first part of the presentation today. What we have in mind is to take you through the various stages of a corporation's, specifically a private corporation's, life. The creation of the corporation, its setup and structure, its financing, the development of the corporation, and the extraction of funds and profits out of the corporation. Today we are going to do the financing and structure and focus on the extraction of funds. We hope in subsequent sessions to do various other integrated aspects of corporate organizations, reorganizations, restructurings, and so on as part of this same set of materials. You have in your materials a small case study which I've put at pages A1 to A4, and some of you may not have had the time to look through this, So let me just briefly set the scene for you. What we are looking at here is a fairly small business operation where a person who owns the shares of this business entity wants to get out of the business, and we have three potential investors who may have an interest in purchasing this business. At page 1, I've given you a simplified balance sheet of what this business owns, and assets of 1.035 million, and the way in which those assets have been financed through payables, shareholder loans, some equity capital, minimal equity capital, and some retained earnings. We have three potential investors, each with somewhat different circumstances. Harry Henderson, who has a family of two fairly young children. Jane Blue, who also has children but is now separated, I believe, and a non-resident, Graham Smith, who is willing to invest in the enterprise. What we want to look at is to see what are the considerations that one will look at to structure this organization, finance it, and then Michael Morgan later will tell you after the break of how some of these structural considerations may have importance for getting money out of the corporation, and in what way one can take money out in a tax efficient manner. There is a myth that large organizations require complex structures and small organizations require simple structures. In fact, the principles of structure and financing apply equally regardless of the size of the enterprise, particularly in the context of private corporations. There's very little difference in structuring a $1 million corporation and structuring a $100 million corporation. There may be a difference in the fee which you charge, but there is very little difference in the fundamental structures. The first thing, of course, is the most obvious and therefore is usually ignored by most, is to ask yourself, what is the reason that I am setting up this particular structure? Why do we want to set up a structure in a particular way? That is important because the structure will determine whether it is efficient from a business point of view, and 2, efficient from a tax point of view, and 3, whether it is efficient from an estate planning point of view. And each of those will have different considerations which you will have to take into account. So the first question always is, why are we buying this business and structuring it in this particular way? For the purposes of our discussion today, we are talking about buying a business to be structured in a tax efficient way, but we are not focusing today on an estate planning structure. An estate planning structure may well have different considerations that apply. Our principal focus is on an ongoing business. I invite you to ask questions as we go along if you feel that your question is pertinent to the particular matter being discussed. I'll handle your questions as we go along, or if it is more appropriate, I'll ask you to defer it to the end, depending upon what the question is. The objectives in purchasing a business are set out for you in your materials at page A5. And we'll see how we can develop a structure that in some way satisfies these various objectives. First of all, of course, is the general business objective. And here we are assuming we're using a corporation. Given the size of the operation and the number of people involved, it would be extremely unusual to have this business organized as anything other than a corporation. For example, it would be extremely unusual to use a partnership in a situation such as this, and it would be even more unusual to use a business trust. So you want to structure the corporation itself so that you reduce or minimize its exposure to business risks, which means from our point of view, not only immunizing the shareholder from personal liability for the corporation's obligations and debts, but also immunizing the corporation itself from its debts and obligations, which will be done in various ways. Michael will touch on some of them later on when he talks about asset protection, but for our purposes, we will be looking at the use of a holding corporation to siphon money out of the operating corporation so that the operating corporation's exposure to risk is minimized. Secondly, of course, to strike a balance between debt and equity interests between the owner-managers. The one thing that is common to all financings, the one universal rule, is that there are only two sources of financing known in this world: debt and equity. There is no other source of financing that is available. Debt and equity are the only two sources of financing, and it doesn't matter whether you're financing a mom-pop store down the corner or you're financing General Motors. You have only two sources of financing: debt and equity. After that, everything else is a variation on one of those two forms. Thirdly, we are very concerned not only from a business point of view, but also from a tax point of view in the allocation of control between the participants. Obviously, people who go into a business together want to know beforehand what their control exposure is or what their control power is. For business reasons, what can I do? How much say do I have? Can I get out? When can I get out? Etc. From a tax point of view, control is extremely important because under the Canadian tax system, we have a preferential tax regime for Canadian controlled private corporations, and the concept of control is a central element and determinant in that preferential tax system. And next, in structuring a corporation, you always, of course, keep in mind that ultimately you're in this corporation for one reason and one reason only, and that is to make money. And that eventually, at some stage in the process, you will want to extract that money or pass it on in some form to the next generation. Because no matter how much you make, you will ultimately meet your maker, and you have to plan for that. And related to that, of course, you have to ensure that at the appropriate time, there is a market for you to get your money out. That is, you are not locked into an investment that is not marketable or is so liquid that you cannot extract your funds. So those are the broad general objectives that we are concerned with. Reducing that down to the tax objectives, we are concerned with two things. We want to do all of these things. We want to pay the least amount of tax on a current basis. We want to minimize the income tax on an annual basis, and we want to maximize the amount that we can extract from the corporation on a tax-efficient basis later on. We, in tax jargon, refer to this as income splitting and capital splitting. I'm going to focus principally on the income splitting aspects, but the corporate structure that we will talk about will have a bearing not only on the current income splitting status of the corporation, but also ultimately on what Michael will talk about on the capital splitting when funds are extracted. They are interrelated. How you set up the corporation today determines how you will capital split tomorrow. At page A6, I've set out for you something that you probably are fully aware of intuitively from your own personal circumstances, and that is what income splitting really comes down to. It's a very simple numerical example that shows you how much tax you would pay and therefore how much you would save by multiplying the number of taxable persons or bases paying the tax. So that obviously the worst case scenario is for one person to go out and earn $300,000. That's for a person who has a family. If the person has no family, then that person must suffer the $300,000 alone. But if the person has a family, that is the worst case scenario. You can see by moving up that scale or down the income scale that if that person instead could multiply $75,000 four times, or had four taxable persons in the family, that person would be paying only $108,000 in tax and saving $36,000. At $50,000 and six taxable persons or six taxable bases, you have a total tax saving of $55,000. Now, this is something that is inherent in the system, and therefore it goes to our fundamental planning. We want to multiply the number of people who own the business is objective number one. Why? Because of that table, the progressive scale. Unfortunately, life gets complicated from here on, because not only do you want to income split, but in most cases, you also want to maintain some form of control. And here you have the conflict between control or voting power, the ability to run the business and make its decisions, and two, having the interests of the business split amongst various persons so that you can reduce your overall tax base. The first decision that you will have to make in this enterprise, and I've made it for you for the purposes of today's discussion, is whether you're going to purchase assets or you're going to purchase shares. For our purposes today, we're confining our discussion to a purchase of shares. A purchase of assets requires different considerations that will not be covered today. But that is a fundamental decision that needs to be made, whether you're going to purchase assets or purchase shares, and the interests of the vendor and the interests of the purchaser are quite different. Generally speaking, a purchaser will prefer a purchase of assets. Generally speaking, a vendor will prefer a sale of shares. And the after-tax values of these two transactions, a purchase of assets or a sale of assets versus a purchase and sale of shares, has to be determined, because the consequences to the vendor are different if he or she sells shares, and therefore those tax savings will have to be factored into the purchase price. purchase of assets is generally advantageous for a purchaser because the purchaser can step up the cost base of the assets purchased. And this is extremely important in some acquisitions. By step up the cost base, you will recall from your days in tax classes and bar admission or law school or wherever, we mean simply the base at which you can take your depreciation or capital cost allowance. The higher that base, the higher the rate that you can write off, and the more or the greater the advantage. So from a purchaser's point of view, for example, with a building, a purchaser would prefer to have a building valued at $500,000 rather than $100,000 because it gives a larger depreciable base. The vendor, of course, is positioned exactly the opposite. The vendor is very concerned about having a high value placed on depreciable assets because the vendor becomes exposed to a recapture of depreciation that may have been claimed in the past. And the vendor is, of course, concerned about that. Now, at page A10, I give you a brief overview of the various considerations that determine what affects a corporation's tax status or its tax liability. First of all, the status of the corporation itself. Generally speaking, and for the purposes of today's discussion here, we are concerned primarily with Canadian-controlled private corporations. And Canadian-controlled private corporations in Ontario today have a tax burden of approximately 23 percentage points on the first $200,000 of active business income earned by the corporation. $200,000, 23 percentage points. A top rate Ontario shareholder today would pay tax at approximately 53 percentage points, which means that you get a tax saving of approximately 30 percentage points. Now, that's not absolutely an accurate statement because one is a flat tax and the other is a progressive tax, but there's still a very wide spread between what a private corporation pays on the first $200,000 of its active business income versus what a high income taxpayer would pay. And you will recall that as part of the social contract negotiations, the doctors won the right to incorporate. And of course, that was the trade-off. The trade-off was that they would drop their tax bill. It is more likely that they gained more in that deal from the right to incorporate than the income that they would lose as a result of the social contract negotiations or the negotiations with the profession. We'll come back to that point and look at some numbers to show you what the effect is, but it is an extremely important aspect of our lives if we can come in under this CCPC status. We have to be concerned about this in our fact scenario here because you will recall one of the potential investors is a non-resident of Canada who has probably more money than the others. And we are concerned about control because control means not only for our purposes legal control or de jure control that comes with share ownership, but we are also concerned with de facto control or control in fact. And we want to be sure that this corporation, whichever we set up, for these people is not controlled by the non-resident Graham Smith. The next element you see in that list is the nature of activities and income. We do not need to concern ourselves excessively about this issue at this time, other than to mention it in passing. The preferential treatment that we refer to, the low rate of tax, attaches only to active business income. It does not attach to passive income or investment income. And there has been a lot of litigation on this issue as to what constitutes active business income versus passive income, and it rears its head in all sorts of scenarios. Fortunately, the taxpayer has been winning more and more of those battles, at least on the domestic front. And the taxpayer has won. That's an issue that's extremely important also on the international front if you are doing cross-border transactions and you're investing outside. But that, again, is beyond the scope of our discussion today. Active business income. Here, in this area, all you need to remember is the presumption which Madam Justice Bertha Wilson raised in a case called Canadian Marconi, which was at the Supreme Court some 10 years or so ago, where she said that there is a presumption that income earned by a corporation is active business income or is business income. The authority, other than the source of the statement for that proposition, is dubious, and no one has quite been certain where that rebuttable presumption came from. In fact, on the contrary, our statute is so structured that we have a deliberate and separated scheme of taxation for investment income and business income. Nevertheless, given the stature of the source, the Supreme Court of Canada, that is a very good presumption to have in your hip pocket whenever you want to characterize income as business income. Business income is taxed at 23%, investment income at 44%. So you want to be on the right side of that presumption if you are talking about income below $200,000. At income above $200,000, it is generally better to be characterized as having earned investment income rather than business income, because investment income gets a refund of tax and the rate drops from 44% down to 33 or so percent, whereas the tax on business income stays up at the high rate of 44. So once you cross that threshold, that presumption becomes inconvenient, and you must then distinguish it and say there is no real authority for this presumption based on the policy of the statute. Of course, if you're really sophisticated, you will argue that the presumption applies to the first $200,000 and is rebutted above that amount. That, of course, takes a certain amount of skill in reasoning that I'm sure you're quite capable of. Now, let us assume for today's purposes that they are going to purchase this corporation and they are going to come in as follows. And I'll tell you why I think that this is a reasonable way to go. There is obviously no absolute solution to this case. You can do whatever you wish with it. We can only offer some suggestions as to why certain structures would work. First of all, I suggest to you that Henderson and Bloom Jane Blue and Harry Henderson should own their interests in the corporation through another corporation. That is, they should have their interests in this operating corporation, Peterson Enterprises, held through a holding company rather than directly. Why? Well, it meets the first objective that we talked about. It insulates OpCo, the operating company Peterson, from business risk, because at the end of the year, they can siphon out any of the money from the operating company and pay it up in the appropriate portions to their shareholdings, and we'll come to that question in a moment, but they can pay it out to the holding corporation. Now, the operating company at that stage would require, obviously, some operating assets and working capital. That money can be sent down back to the operating company in the form of an intercorporate loan. If that is done, the holding company, in fact, now becomes a creditor to the operating company as well as being its shareholder. All right, so the structure is fairly straightforward. At the base, you have Peterson Enterprises, or the operating company. Above that, you have one holding company on this side for Harry Henderson, and one holding company on this side for Jane Blue. Note, we are not putting a holding company in for Graham Smith, because he is a non-resident and different considerations would apply to him. When the operating company moves the money up to the holding company by way of a dividend, the holding company is not taxed on that dividend under Part 1 of the statute. It is not taxed on that income because it is an intercorporate dividend. Instead, the holding company will pay a special tax, what we call the Part 4 tax, on that dividend. But that tax is a fully refundable tax when it is ultimately paid out to the individual shareholders. It is thus only an anti-deferral tax, and it is not anything more than that. It is not a real tax in the sense of taking a permanent bite. It is an anti-deferral tax. Now, at this point, I realize it's 2 o'clock in the afternoon on Wednesday, or it's nearly 3, and you're probably not overly excited by this subject, but is there anything that you want to raise? Are there any questions that you wish to raise at this point? I see that you have not become much livelier since you graduated from law school many years ago, and you've remained the same. Well, that is good. There's a certain element of consistency in your lives. Now, you've got two structures then, two holding corporations that own the shares of this operating company. You have to be extremely careful in this context because you have a non-resident. If you didn't have a non-resident, this consideration would not apply. That the control of the corporation is not in Graham Smith's hands. Graham Smith is the non-resident living in New York. And when I say control is not in Graham Smith's hands, I mean not only legal control, I mean also de facto control. The test, which is found in section 256 5.1 of the Act on de facto control, is an extremely broadly worded test because it says in substance that where an individual, where a person has a power or an influence that, if exercised, would render control in that person, then control in fact belongs to that person. That is, what they're saying is that if you have sufficient influence, which although you have not exercised at the present time, but if you exercised it, you would have control, then you in fact have control now. It's an influence test rather than an exercise of power test. And that, of course, is a very difficult and elusive test, because a large creditor, such as Graham Smith, financing a substantial amount in the financing of the corporation, can have control, real power, as opposed to legal control. If that occurs, the corporation becomes a non-resident controlled corporation, and then the entire scheme collapses, in the sense that all of these advantages of the low rate of tax of 23% on business income will not be available to you. The only other aspect I mention about that is that the test for control is that control cannot be in a non-resident corporation if you want to be CCPC, if you want to have CCPC status. The test is stated negatively. That is, 50% outside the country is not controlled. 50% in the country is sufficient for control. The test is that it must not be controlled by a non-resident. Now, we come to one of the more controversial issues, and that is the question of how do you structure the holding company itself. Here I'm going to focus on Henderson for a moment. Harry Henderson. Similar considerations apply to Jane Blue. Henderson is a family man. He has a wife and 2 children, one of whom is a minor and the other is 19 years of age. So he has available in his family the potential for splitting income amongst 4 persons. Obviously, the considerations that apply to the 4-year-old will be different from those that apply to the 19-year-old, but the objective is the same: to split income between Henderson, Mrs. Henderson, and the 2 children. Let me take you for a moment to 4.1, page 4.1, immediately after the case. These numbers are intended as illustrative only, and they are not intended to strike terror in you. Option A shows you in that column of option A the operating company paying a dividend or salary down to the individuals in their personal capacity. There is no holding company in this particular scenario here. Exactly the same numbers would apply if you did interpose a holding company, because, as I say, a holding company acts simply as a flow-through mechanism for the operating company. It doesn't change. You pay the tax, you get a full refund of the tax, and it is a transparency. You see, in option A, first of all, we have the corporation earning $275,000. The first point to be made is that this is above the business limit, and therefore, if you look down at the bottom number, the total tax, $119,000, you see that this is a very expensive number. This is the highest number of all of the tables that you have. The reason for this is very simple. The $200,000 that attracts tax at 23%, the low rate of tax, that privilege is no longer available for income above $200,000. And any income above $200,000, in this case $75,000 above that threshold amount, becomes a subject to a double tax. And it is extremely expensive to have more than $200,000 in the corporation. So rule one is you want to make sure that you get that income level down to $200,000 in the year. It is not simply tax neutral to leave it in the corporation. There is a tax penalty attached to it. In option B, what we've done is basically paid a salary to Henderson of $150,000. You will notice, first of all, and these numbers, as I say, are merely illustrative for certain points, but not intended to be a comprehensive presentation. But you will see that I have tried to make a comparison of various scenarios by keeping total family income at $150,000. You can put whatever number you want in there. The principle will remain exactly the same, but you will see in all of these tables, I have tried to keep the family income at $150,000. So we pay $150,000 in salary to Henderson, and that income now, that tax burden drops down very substantially, obviously, to the corporation, because the corporation gets a deduction for that amount. But Henderson himself, Harry, has to include that amount in his income, of course. And I have made the assumption that he takes the maximum amount that he's entitled to by way of a contribution to the registered retirement savings plan, and then after that it's simply a question of the numbers working through. Now, one of the questions that will come up in the structure of the holding company, which you have set up for the Henderson family, which owns a percentage of Peterson Enterprises that they have acquired. Let us assume for present purposes, just to keep it simple, that the Henderson family owns 25% or, sorry, not 25, 50% of Peterson Enterprises, and Jane Blue owns the other 50%, and that Smith comes in with loan capital. Henderson, in the holding company, will want to structure his holding company so that all members of his family participate, which means he will want them to hold shares in the corporation. Why? Because shares will entitle them to dividends. And the magic about dividends is that a taxpayer in Canada earning dividends from a Canadian corporation, a taxable Canadian corporation, can earn $23,700 roughly without paying any tax. There is zero tax on approximately $23,700 or so of dividend income. I have it at table 4.5. You see a dividend being paid to the children, which is the last two columns on the right, $23,745. If you look down to the total tax in the last two columns, you'll see it is zero. Those two children are not paying tax, even though they have $23,000 in income. For those of you who are interested in the exotica of this subject, the reason for that is because the children, although they include the amount in their income, which I've done, grossed up by 25% at $29,681, get a dividend tax credit. A dividend tax credit which is supposed to compensate them notionally for the tax paid by the corporation. The result of it is that they do not pay any tax. The planning consideration is that this is an extremely effective and efficient way to structure a family corporation. Most people, or a lot of people, of course, pay for their family's well-being, upbringing, and welfare with after-tax dollars. That is, most people go out, work, earn their income, pay their tax, and then with what is left over, they send their children to schools, summer camps, buy them tennis rackets and things like that. You're spending after-tax dollars. Out of every dollar that you've earned in a high bracket, the government leaves you with 47 cents. You then go to the shop with that 47 cents and buy your child the tennis racket. It's an expensive racket. You'll pardon the pun. What you want to do is to give that child money of their own, which they can then take and go to the store and buy their own tennis racket. There is no law that says a child cannot pay for his or her own school education or summer camp or ski holiday or what have you. And the fact that the child is only 5 or 8 or 10 or 12 or 14, it makes no difference whatsoever. A juvenile, a minor, can be financially self-sufficient. So what you want to do is make sure that they are in a position to get that money. And obviously, the only way they can get that money is either through, well, there are 3 or 4 ways. 2 of them are seriously considered, and the others I wouldn't recommend to you. First of all, through dividends. To have dividends, you have to have shares. Secondly, the other option is to get it to them through salary. The disadvantage of salary or wages is that you have to work for it. And a minor child cannot usually offer much by way of work to the business. That'll vary depending upon the age of the child. Obviously, a 17, 18-year-old can offer much more by way of services than a 4-year-old, but there's a limit to how much you can compensate your children. There's a test that the department will apply, and if you compensate your child too much, they will disallow the deduction. The disallowance, by the way, is extremely expensive because it's disallowed to the payor, the corporation, but it remains taxable to the payee child. So you get hit twice. There's a famous Nova Scotia case where a taxpayer paid his wife $150,000 of salary income. She was acting as his receptionist. By any standard, even by the high standards of downtown Toronto, $150,000 for a receptionist 15 years ago was a fairly extravagant sum of money. They disallowed the corporation the deduction, which means they pay the tax in effect on the $150,000. But since she has actually received the income, she of course remains taxable on the $150,000. They simply disallowed it to the corporation on its reasonableness amount. They did not say, therefore it does not constitute salary. It does constitute salary. You are taxable on it. It just happens to be an unreasonable amount. other two ways of getting money to a corporation I wouldn't consider seriously, and that is through shareholder benefits and such like. That is allowing people to use corporate assets. They are not very advisable, and Michael will talk about it later on. However, coming back here for a moment and jumping down to pages 4.4, which show you dividends, 4.5 and 4.6, which show you a combination of dividends and salaries, you'll see that the total tax burden begins to drop in each one of those illustrations. That is, option B is always cheaper than option A, because option B splits the income in various combinations amongst the various participants, whereas under option A, it's always with one person. So option B shows you splitting is more efficient than non-splitting. But then there are various forms of option B which tell you that various combinations of dividends and salaries can be more efficient than others. Generally, you should have a mix between the two, the reason being because the salary income allows you to take your registered retirement savings plan deduction and contribution, and the dividend income, as I say, comes to the children tax-free up to $23,745 of that type of income. Now, we come to the next and perhaps, in a sense, the more important aspect of the structure. And here I want to take you through certain rules. I have set this out in some considerable detail in the written materials, and I'm sure you'll read them at the appropriate time. But I want to highlight 3 or 4 aspects of the decisions that govern this particular area of the law that are particularly important for you. We want the shareholders, we want the family members to be shareholders in the corporation. But obviously, we do not want all the 4 family members to have an equal say in the corporation. One of the children is only 4 years of age, and the other is 19 and is playing tennis at Harvard. You want these people, the 4-year-old and the 19-year-old, the son and the daughter, to receive income but not have control. So we would set up the holding corporation typically with a minimum of 4 classes of shares. A minimum of 4 classes of shares. One class, we'll call it Class A for Harry, Class B for Harry's spouse, Class C for the first child, Class D for the second child. These shares will have certain rights, conditions, privileges, and restrictions attached to them. And those conditions, privileges, and restrictions that you will have attached to them depend upon what you want the various people to do. But at the very least, you want them to be different because you want to be able to flow dividends to one class without necessarily in law being compelled to flow dividends to another class. For example, let us say in a particular year, one of the children, the 19-year-old studying at Harvard, has greater financial needs than the 4-year-old who is at home. You want to be able to flow dividends to the 19-year-old child without in law being compelled to treat the other shareholder, the younger 4-year-old child, in an equal manner. If the share conditions are silent on the point and they have equal, the same type of shares, there is a presumption of equality in law. In corporate law, which will flow through to tax law, and you will be considered to have made a dividend payment in equal amounts to the two shareholders. We use what is called a discretionary dividend clause. And the discretionary dividend clause basically says, and it is in your materials, you will find it as part of the McClurg decision, which you see under tab 4 behind your yellow materials. The McClurg decision, which came down from the Supreme Court of Canada, and basically sets out the principle that you can have discretionary dividends to the different classes of shares, which you will find at page 4B of the decision. You see, in McClurg, they had Class A common, Class B common, and Class C preferred. And notice the clause that says in those classes of shares that they shall be participating shares, and they will have the right to receive dividends exclusive of the other classes of shares in the said corporation. In other words, under the McClurg structure, you could pay on Class A, B, or C preferred to the exclusion of any of the others. It gave the paying corporation the flexibility. The McClurg Corporation was, in fact, a family corporation of Mr. and Mrs. McClurg, who had gone into business with two other members. You'll find them in the decision, the Ellises. There are two aspects of the McClurg decision that are important for us. The first is that the court says that discretionary dividend clauses are valid. Secondly, the court says that in the case of private corporations, in which people are not dealing with each other at arm's length in these family corporations, these discretionary dividend clauses are valid, but the court raises a cloud as to what might happen if, in this case, the spouse, Mrs. McClurg, did not make a contribution to the corporation. A contribution to the corporation. It doesn't decide the point, it just simply raises a cloud as to what might happen. That is, if you have a passive shareholder who does nothing at all except receives a dividend check at the end of the year, the McClurg decision left that issue under a cloud. In the particular case, Mrs. McClurg was making a contribution to the business, and therefore that issue did not have to be decided by the court. But in a statement that was somewhat characteristic of the Supreme Court of Canada, it said, this other matter we will not decide, but it may raise certain issues. And having said that, of course, it created a great deal of uncertainty. So discretionary dividend clauses are valid. That they've told us with certainty. They're certainly valid where there has been a contribution. That they've told us with certainty also. And there might be some slight doubt over the matter if there was no contribution. Shortly after came another decision called Newman. Newman, in fact, is also in your materials. Newman is a decision originally out of Winnipeg, a lawyer who set up a management corporation. And of Of course, his spouse could not participate in the law firm, being a non-lawyer, but she could participate in the holding corporation, in the structure that we are talking about today for holding this business. Mrs. Newman did not make any contribution to the business at all, so it was a classic case, and it squarely put before the court the very issue that the Supreme Court of Canada in McClurg had raised questions about. So the question came to the court on the basis of no contribution by the spouse. It went up through the tax court and then up to the federal court trial division, and Justice Rothstein in the federal court said, no, it's okay. It's acceptable to have income splitting in effect even where there is no contribution by the spouse. So it takes us that extra step from McClurg and allows us to income split between participants who have made no contribution. This is, of course, an extremely important point in every family corporation where you have a non-contributing spouse or a non-contributing minor child. I believe Newman is on appeal to the Federal Court of Appeal, and it'll be some time before we know the stature of the decision. But that's the state of the law as it stands today. So the structure then that I would propose to you in the purchase of this business would be a holding company holding the Henderson family's interest in the operating company. The holding company to be structured with 4 classes of shares. Each class would be distinct and different and would be allowed to take dividends to the exclusion of the other classes. Harry Henderson, being the dominant force in this business from the fact situation given to you, could control the corporation by holding 51% of the voting shares of that corporation. The other shares could be non-voting. They would be, of course, fully participating, but they do not have to be voting. And if you wanted to draw a distinction between the classes of shares, the easiest way to draw a distinction between shares is to give different shares different votes or different weighted voting. That is to say, if you had Class A shares, let's say to Harry Henderson, you might attach 100 votes a share. You had Class B shares, you might attach 10 votes a share. You had Class C shares, you might attach 2 votes a share. You have Class D shares, you attach 1 vote per share. And you have the discretionary dividend clause, which of course you draft using the language of the McClurg clause, because that has been blessed by the Supreme Court of Canada. You lift the clause from there and put it into your articles of incorporation. You can still treat the various family members equally in the sense that if you gave one child 10 shares with 1 vote, Class D shares, you could give the other child 5 shares with 2 votes each. They would have equality of voting power, 10 votes each, but they would in sum and substance own 2 different classes of property, and you could declare a dividend to the one class without declaring it to the other classes. That would allow you the opportunity to then pay dividends to those members of the family, in our case, the Henderson children, who could then pay for their own expenses out of their own finances, rather than you paying for those expenses out of your after-tax dollars. There are 2 or 3 other questions that I want to address with you, and then if you are so inclined, you can raise whatever questions you want. First of all, there's always a fundamental question as to whether you want to finance a corporation with a large amount of equity capital or a small amount of equity capital. This is both a business decision and a tax decision. Obviously, the less the equity capital, the lower your exposed risk. But if you are in a business where a certain amount of financing is required, if you do not have enough equity capital, you may well be called upon for personal guarantees, which in effect will expose you to the same element of risk, at least insofar as your bankers are concerned. No matter how much you put into the corporation by way of equity capital, what you put in will be referred to as the paid-up capital of the shares. You can extract that paid-up capital without any immediate tax cost. That is, Michael will go into this in greater detail later on, the paid-up capital of a corporation can always be extracted without any tax cost. We have an income tax system. We do not have a capital tax system. That is the paid-up capital of the shares. The paid-up capital of the shares must be distinguished from the adjusted cost base of the shares. Paid-up capital is a characteristic of the shares. It belongs to the shares. It is an attribute that attaches to the shares. It is not a characteristic or attribute of the shareholder. It belongs to the shares. It moves with the shares. It goes with the shares. The adjusted cost base of shares is an attribute that belongs to the shareholder, not to the shares. What does this mean when you're buying a business? It means that if you are buying a business or buying shares, if they buy Peterson's shares, those shares have a paid-up capital, which I think in our particular case is very low. It's $1,000. It was the paid-up capital of the shares when that business started, which basically means you can extract only $1,000 on a tax-free basis from those shares. If that amount was larger, however, let's say you were buying shares that had a paid-up capital of $1 million, which would imply that you can extract $1 million on a tax-free basis, you want to be very certain that the paid-up capital for tax purposes is exactly what it is also for corporate law purposes or financial statement purposes. You do not want to be surprised by buying shares which have a balance sheet stated capital, let us say of $1 million, to discover later on that they have, for tax purposes, a paid-up capital of, let's say, 0. Because you would then lose the $1 million tax-free zone that you would have had to extract those funds on a tax-free basis. You would be very unpleasantly surprised. So that you want to be absolutely certain, and you will obviously obtain the appropriate warranties and representations, that the paid-up capital is the same as the stated capital for financial statement purposes. That information may not otherwise be available to you. It is not information that will appear obviously on the documents, and it is not information that will appear on the financial statements. You will have to go in search of that information, because the event that reduced the paid-up capital may have occurred a long time ago pursuant to a deeming provision of the Income Tax Act, and it'll not appear on the face of the record, so to speak. In contrast, the adjusted cost base of the shares is simply the price you pay for the shares, and that, of course, will be the floor from which you determine the capital gains and then calculate your gain or exemption, as Michael will discuss a little later on today. The final point I want to make is in respect of the two children in our scenario. We've got a holding company with 4 members of the family, the Henderson family in this case, mother, father, 2 children. Children are minors, one of them certainly is. You can read about the attribution rules and all that. They're all in your materials. In respect to the 4-year-old child, Mark, you want to be careful that the funds that Mark uses to purchase the shares are independently acquired funds, and that they are not funds that have been transferred to him by Harry, his father. And you want to maintain a very clear record to show where those funds came from. Until last year, this was very easy to do because of the family allowance check. The family allowance, although paid to the mother, Revenue Canada accepted was the child's money, or although it's the mother's money, the child could use it, and they accepted investments out of that. But now, of course, we don't have that. So the child must acquire independent funds to make that investment. Or, if the child does not have independent funds, you can get those funds from a non-resident. You do not want them from a resident, a Canadian resident. You get them from a non-resident of Canada, grandparent or other relative. You're only in search of $1. In fact, you're actually only in search of a penny, so that you might be able to get it from any non-resident. But you will want to maintain a very clear trail to show where those funds came from. Otherwise, the attribution rules will apply. You will interpose a family trust. You will interpose a family trust between the child, of course, and the corporation. Obviously, a 4-year-old cannot act for himself, and therefore you will have to create a trust for the child. That is not complicated, and the trust is a transparency, and everything flows through the trust insofar for tax purposes. The child pays tax at the child's rate, which is obviously 0, up to, for income up to $23,000, and the trust bears no tax at all. The mechanism for that is what we call a preferred beneficiary election is made. Preferred beneficiary election is made in this case for Mark, the 4-year-old, who pays tax on the $23,750 as if it was his own money. The tax bill is 0. The trust does not pay tax on that amount. The trust is in effect for tax purposes a transparency. The trust will, of course, require trustees, and either one or both parents can be trustees of that family trust. These structures need to be carefully considered and documented, obviously. They are always under scrutiny by Revenue Canada. The McClurg case, the Newman case, the Kaiboom case, all 3 of which are in your materials, illustrate how they look at these cases. Revenue Canada feels a certain degree of dissatisfaction when it sees these schemes because it reduces the tax bill, albeit legally, but they feel unhappy about it. And they will look to see that the scheme is put in place properly and that all formalities of corporate and trust law have been met. Now, if I hear any questions, I'd be happy to answer them at this time, or if I don't, you may prefer to just take a break for a few minutes, have some coffee, and then hear Michael Morgan speak on how you get money out of the corporation. So, sorry, at page A32, did you say? Yes. Anybody. You can issue the shares to anybody. Yes, usually though, in most of these scenarios, we only give the shares to family members because we want the income to stay within the family. But there's nothing in law to prevent you from giving it to anybody else. It is simply human nature that prevents you from doing that, but not law. Yes, you can do. Parents are never a problem. That is, upstream splitting is never a problem, because with upstream splitting, that means to parents and grandparents, etc., the attribution rules don't apply. So it's never a problem. It's always been easy to arrange upstream splitting. It's downstream splitting that has always been technically a difficult area, because with downstream splitting, you're usually talking about people under the age of 18 years, and the attribution rules kick in at that time, and that's what creates the minefield. But upstream splitting is not a problem. In fact, if you wanted to look after your parents or grandparents, etc., that's very easy to arrange. The operating company, you have basically two very important constraints in the fact scenario that you've got here, and that is that these people have they do not have enough money to buy this corporation. That is Henderson and Blue. But the key is that they want to be treated equally for business purposes. So you're going to want to do two things. One, you'll want to maintain a minimum of 50% of the shares controlled by Henderson and Blue, a minimum, because you'll want Canadian control. The maximum that you could give Graham Smith here would be 50%. As between Henderson and Blue, you would then split it probably to satisfy the needs in the fact scenario 25% each, because they want to be treated equally. Now, obviously, you can vary that. If you gave them 70%, they'd take 35% each, and then Graham Smith would take the remaining 30%. But those are your two constraints. One is a business constraint, they want to be treated equally, and the second is a tax constraint, they must have a minimum of 50%. The situation in respect of Graham Smith is not discussed because it raises all sorts of international tax questions that are not germane here, but there will be considerations as to how he will be treated in the United States, the withholding tax on dividends if he becomes a shareholder, the withholding tax on interest if he injects debt capital into the corporation, and so on, but they go beyond the scope of our discussion today. Any other questions? Paid up capital is at inception a very easy concept. If you buy shares the inception of the business for $1, that is the stated capital for corporate law purposes, and it is also the paid up capital for tax purposes. So at inception, it's very easy. Paid up capital is equal to stated capital, which is basically the capital contributed by the shareholder in cash or kind. Where it becomes far more complicated is that down the road, if you engage in certain corporate reorganizations and share reorganizations, paid up capital can be adjusted for tax purposes. It can be deemed to be something else for tax purposes without having any effect for corporate purposes. And the two figures can then vary. That's very technical, and obviously we cannot go into it here, but I would give you this caution, which would put you on guard. Anytime you are doing anything in a corporation that affects the shares of the corporation, you worry about paid up capital. Anytime you are doing anything with the shares itself, that alarm bell should go off in your mind and say, I once went to a seminar years ago. They told me about paid up capital adjustments. I know nothing about it, but I know that it's serious, and you call somebody. And that's all you need to remember. I could take you through the deeming provisions, but I don't think on this nice Wednesday afternoon you are in the mood for that. Well, I'm not sure we want to call it out, do we?
Well, I'm not sure as a lawyer I want to give an opinion on paid up capital either.
Well, if you're engaged in a share transaction that has paid up capital consequences, the most likely scenario that you're going to run into rather than the accountant is when the shares are being purchased or sold. Of course, and you're more concerned about it from the purchaser's point of view. The vendor doesn't care. The vendor's disposing of the shares. Paid up capital goes with the shares. So what? They're $1 million lower than what they are on the financial statements. That's not the vendor's concern. So the purchaser's concern is to obtain a representation from the vendor that the paid up capital of the shares is equal to the stated capital of the shares on the balance sheet. And to obviously have all the appropriate protection around that fundamental clause, because it's an extremely expensive mistake. If you have paid up capital of $1 million, it effectively means you can get $1 million out of the corporation without any tax consequences. Zero tax cost. If suddenly you discover that it's not $1 million but has been deemed by the statute to be $100,000 because of a transaction that occurred 15 years ago, you have lost $900,000 of tax-free money. And in this day and age, you do not want to make a mistake of that magnitude, not with the crisis we face with the E&O insurance and related matters.
If I can just add one comment to that. Despite what I said about not wanting to give opinions as to paid up capital, that's probably the one exception to the general rule, which is wherever there's a financial matter, ask the accountant to provide the opinion, because the accountant will invariably come back to the lawyer and say, we've been carrying this on the financial statements for X number of years, it must be right. The bottom line is you have to trace through the minute book to find out what the paid up capital is. That's the only way to properly determine what the paid up capital is. So as Vern says, if you're acting for the purchaser, if you do a minute book search, you're searching a minute book that you have not been maintaining. So even though you can do a determination, you have no idea if it's right. So that's why you have to get the rep and warranty on the paid up capital.
to why it would not be wise to go down to $200,000? I would think it would be extremely unlikely that you would not want to go down to $200,000. It would have to be a very rare situation, because I don't have the numbers shown here, but you can get it intuitively from these tables at 4.1, which shows you active business income in excess of $200,000. There's a very substantial cost. You will end up paying tax at the corporate level, and you will get a dividend tax credit. Let me back up a moment. The scheme that we have works as follows. For those of you who may have forgotten the concept of integration. The concept of integration theoretically is a very attractive notion and a very sophisticated notion. It says simply that the corporation pays tax, we flow that income from the corporation to the individual, and then the individual gets a credit for the taxes paid by the corporation. That's a very simplistic version of what integration is, but it is based on certain fundamental assumptions. It works perfectly if the corporation has paid tax of 20%. That's rule one. 12% federal, 8% provincial. It works perfectly, and it is built on the assumption that the corporation has paid tax at 20%. It works perfectly if the shareholder is paying tax at a rate of 40%. That's the other assumption. Now, from the government's point of view, it works perfectly if the corporation has actually paid the 20% tax. In fact, as in most things in life, all three assumptions tend to be somewhat skewed and not in place, because the corporation does not pay tax at 20%. It pays it in Ontario at approximately 23%. Secondly, shareholders do not pay tax at 40%. That was in a different era when we used to talk about those rates. We now talk about rates at 53%. Thirdly, the corporation pays tax on income above $200,000 at around 44% in Ontario. So what happens is, for all of that income above $200,000, you end up paying the corporate tax above 20% and getting a dividend tax credit on the assumption that the tax was 20%. The bottom line of it is that it is inordinately expensive, and there is a penalty. There's a demonstrable penalty of using the corporation in those circumstances, and you would pay less tax than if you held it. You would pay less tax if you held it as a proprietorship in those circumstances. I would, without sitting down and doing my sums exactly, my starting point would be, no, reduce income to $200,000, unless there's some inordinately unique circumstance that applies to the particular case. Well, I've kept you a little longer than I should have. Perhaps we'll take a break here of 10 or 15 minutes, and then Michael will give you some information on extracting funds. Thank you. Thank you.